Okay. Hello all, welcome to the Sahamati webinar on Digital Personal Data Protection Act 2023. I am Rutvik Paikine, Policy and Communications Analyst at Sahamati. And I'm very glad to host Mr. Rahul Matthan, who is the partner founder at Trilegal and heads the TMT practice there as an attorney who specializes in telecommunications media law. He has extensive experience shaping tech policy landscape in India, who has also been invested in the data protection journey of India since its inception. So we are very inclined to understand how your perspectives look at the future of digital data protection in India. At the same time, we are joined by Siddharth Shetty, who is the co-author and architect of DEPA, the Data Empowerment and Protection Architecture, and also the co-founder of Sahamati. So we're looking forward to this conversation. This webinar would be in the form of a dynamic conversation between Rahul and Siddharth, and who will delve into how digital protection regime starts from this act, which is not the end in itself, it's a means to achieve the larger goals which the ecosystem as well as the stakeholders achieve of. So the outline of this conversation and this webinar would be, we would like to understand the implications of this law. At the same time, get into the niches of the account aggregator ecosystem and understand the diverse use cases that might crop up after the legitimizing of this act. So over to you, Siddharth and Rahul.
Thank you so much, Ritvik, and thank you so much, Rahul, again, for taking the time out and having this session today. And what I thought we could start with is maybe a bit of the journey, because it's been quite a journey to get here, probably over a decade around India's journey with regards to how we view data protection, how we view privacy, our relationship with some of these constructs, both within the domestic ecosystem, but also given the various forces of change that have been happening globally, and other countries have been making steps, their own steps towards protecting data and protecting individuals' privacy. And so therefore, maybe, Rahul, it might be useful to just hear from you. You've been involved in this right from the early days. What really started that journey? How did it start? And why is this important, this particular moment over the last few weeks where DPDP got approved by both the Lok Sabha, Rajya Sabha, signed by the president, and has now been notified as an act?
So first of all, great to be here. I think it's particularly significant to be discussing this in an account aggregator and a DEPA context. And I'm glad you mentioned a decade, because most people sort of start the history at about 2016, 2017, which is when this most recent round of discussions start. But actually, my personal association with the data protection law dates back to the 2010-2011 timeframe, when India had just started out on the Aadhaar journey, which is the foundational digital public infrastructure that India built. And in the background of that, there was a discussion about the need for some sort of consideration around privacy, considering that once Aadhaar came about, we would have a digital identity. And once you have a digital identity, it sort of increases the focus on the need for privacy for individuals who could now be personally identified. And so, in many ways, I think the India's first steps down a path towards digital public infrastructure, it actually also marks the origin of the discussion around privacy. And in around 2011, 2012, I worked on what I think is the very first draft of a data protection law. And unfortunately, that didn't come to pass. Government changed. There were actually, at the time, a few committees that looked into it. There was the Justice A.P. Shah committee, but nothing came of it until the challenge of Aadhaar in the Supreme Court. And it was when the concept of the right to privacy was reaching its sort of final stage of arguments before the 9-judge bench of the Supreme Court that the government decided to set up the Justice Sri Krishna committee to create a data protection law. And they sort of put that together. We had many consultations. We had the first draft in 2018. We had another draft in 2019. We had then the final Joint Parliamentary Committee draft. And then after that, that draft was withdrawn. And a new draft was created and presented for discussion in 2022. And it is that draft which eventually became the 2023 Digital Personal Data Protection Act. Now, if you think through that history, I think it would be important to sort of articulate that in a few phases in order to set the context for what I think would be the rest of the discussion. The 2011-2012 draft was, I would say, because I was involved in it, a fairly simplistic draft. It was a draft that just articulated the basic principles of data protection. At that time, India had no idea of data protection. There were no data protection lawyers at all. I remember there was basically only me and a few other people who had some bare bones understanding of technology discussing this. So it's not a very sophisticated, nuanced draft. And then when the 2018 draft comes out, remember that is a time when India has gone through a very vigorous debate around data protection and privacy in the context of Aadhaar. It is also the time when Europe has enacted 2 years ago the General Data Protection Regulation, which was coming into force in 2018, which was the gold standard as far as anyone was concerned around data protection regulation. And so in many ways, the 2018 draft, which spawned 3 subsequent drafts, is grounded on that construct of a European data protection regulation. And every subsequent iteration of the original draft that Justice Sri Krishna created became more and more complex. Now, by the time we reached 2021, 2022, which is when the draft was withdrawn, we're starting to see, even in Europe, a pushback against this very heavy regulatory framing of data protection regulation. And so as we're thinking about, making this draft cover more and more instances of violations by technology companies or just the technology ecosystem, we're at the same time constrained by the fact that putting more and more regulation or having more regulation chase technology companies is not really is proving to be slightly counterproductive in Europe. At the same time, we also have the creation and coming into its full stride of India's digital public infrastructure. We're seeing increasingly this sort of public infrastructure that India is helping build, but which is very much run by private players. And this gives us a new and unique dynamic. And it is around this time as well that we see the birth of DEPA and the Data Empowerment and Protection Architecture, bringing into the vocabulary for the first time this concept of empowerment, which sort of is the underlying feature of European regulation, because European regulation very much puts rights in the hands of what they call data subjects, what we call data principals. But for the first time in the Indian context, can actually be given some strength and some muscle because of this digital public infrastructure that we've built. And so the 2022 draft is the first draft that really leans into this. And I think the sort of the 2023 Act that we have is probably the strongest articulation of this. And we'll get into exactly why. But I thought that that overlay of the two, what's happening in India, what's happening in Europe and the rest of the world, and then this digital public infrastructure would probably be a good foundation on which to have this conversation, since we're going to be addressing the account aggregator and the DEPA ecosystem.
Absolutely. I really like how you laid out that timeline and sort of how it evolved over the last few years, given different contexts that were at play, both internationally as well as within the Indian ecosystem. And I'm taken back to one of the discussions I've had post the passing of the Act. Before we get into the details of the Act itself, is really, why is this important, right? Why is this legislation critical? How does it build trust in the digital economy? Is it even required? Europe attempted something like you outlined GDPR, and it didn't really work. It further strengthened. It hurt competition in many ways and strengthened incumbency, although its intent was different. And I'm often taken back to when I hear some of these arguments. I remember when the central bank RBI introduced the 2FA norms, and there was similar hue and cry saying, look, individuals are not going to be able to do two-factor authentication. Globally, credit cards are all one-factor. And today, with actual innovation through UPI, where you have a one-click experience but two-factor, we have some of the lowest fraud rates globally. And it significantly helped build trust, which in consumers, if you lose it, it's very difficult to regain. And therefore, there are many such legislations which work behind the scenes to build trust within an economy. Many a times companies or market players are not so familiar with, and hence question, why is this important? And this is only going to add to my compliance burden. How do you view that in the context of these developments?
Yeah, so look, I mean, I think in the beginning, when I look back to 2011, 2012, there was a lot of this pushback. Why do we want to do this? And then when the 2018 draft came, because it was very onerous, once again, there was this sort of pushback. But see, at the same time, events have been happening around the world where you recognize that, look, there is value in data. There is, in a sense, power in data. And so we need to have, two things need to happen. We need to ensure that individuals to whom the data pertains should have some way in which to unlock the value in that data for themselves, for their own benefit. At the same time, there's a countervailing fact, which is we want to make sure that the people who control the data don't misuse the data to harm people. And, in that whole time that we've looked at it, we've seen all sorts of instances of how these harms can take place. We've seen, the Snowden revelation. We've seen what happened with Brexit and Cambridge Analytica. And so there's a big sense around the world of the fact that, look, when data gets accumulated in certain hands, it is likely to cause harm. And so if you look at the sort of the global narrative, I think around the world, everyone's quite convinced that there is a need to regulate the use of data. And so a lot of the regulations around the world are very much focused on sort of limiting harm. But in India, I think we realized that India is not economically wealthy, and we realized that India is, because it's digitizing so rapidly, it is very soon going to become data rich before it becomes economically wealthy. And if that is the case, in addition to that harms-based approach, we've got to find some mechanism to allow to ensure that the value doesn't get locked up in the hands of the people who maintain the data silos or who have collected the data, but that it can be more broadly disseminated. And so, in India, we needed to come up with a framing that had this duality. That on the one hand, we don't allow harm to take place, but on the other hand, we allow sort of people to be empowered by their own data. And I think it's a bit of a journey. I think so. You can't come upon this realization overnight. I think if you think back to the right to privacy judgment and all of those sorts of things, it sort of talks us through that harms phase. But equally, if you look at the judgment in detail, there's a lot of reference in the judgment to the fact that data has value and has benefit. And this particularly gets borne out in the subsequent Aadhaar judgment, which said that, which upheld Aadhaar in the context of the right to privacy judgment. And I think, therefore, to answer your question as to what is the need for it, I think these things, if you just leave to market, we're going to find that there are going to be some imperfections. I wouldn't say harms, because when you leave to market, market finds its natural level. But this is not aligned with the way in which we perhaps want to create society. And so, in order to create that alignment, we need to allow the market to flourish such that we can get the benefits of innovation. But at the same time, we need to put the constraints such that it grows in the right direction and achieves whatever our societal objectives are.
Absolutely, and sort of a playground for regulators to regulate, innovators to innovate, as you often say, Rahul. I think one of the key aspects of the bill is really how it's designed around consent. And I remember our early conversations and you had published a paper as well, much more on the accountability regime, which was basically making data fiduciaries, as are known in the bill, which are companies that are processing customers' data, or not just processing, but also custodians of customers' personal data. There should be a regime where they are held accountable because consent is broken, right? And I remember the long discussions we had back and forth in your office, in fact, around a different way to look at consent, and why the traditional model of consent that we often interact with, which came out of GDPR on many of the internet websites, for example, that is broken. Those long pages, completely uninformed. I have absolutely no agency in that equation. And how do you see the current act when it looks at consent, when it looks at individual agency, and also bringing in accountability? That is, consent doesn't fully absolve you of accountability and doing the right thing and doing no harm.
Yeah, look, consent and accountability have to go hand in hand. And so, I think that if you have consent for the sake of consent, that's really not going to work. And I think a lot of what our current practice around the world has evolved to is consent for the sake of consent. And so I think, people know that if they have consent as the ground for processing personal data, that they will be absolved of they can do whatever people have consented to. And so they stuff into the privacy policies all sorts of things that you consent to. And given the volume of consent that is, or the burden of consent that's placed on us through these privacy policies and terms of service that we sign up to, there is this this phenomenon of consent fatigue. We're so tired by the consent that's asked of us that we can't properly provide what we call informed consent. And there is also, because the world has become so much more datafied, and there are so many overlapping demands on our data by various services that often interplay with each other, that interact with us in slightly different ways, that we've got what's called the consent paradox. And that is that in order to fully provide informed consent, you need to have in your mind a vast amount of information, because you can't judge the consequences of consent unless you have this vast amount of information in your mind. And then if people provide you that vast amount of information, it's too much information for you to process. So, on the one hand, you have, so that's why it's called the paradox, because on the one hand, you need so much information in order to actually provide informed consent. But if all that information is provided to you, it is too much for your mind to actually grasp and process. And so, I think that in that context, if this is the way you're approaching consent, that to my mind, you needed to have an accountability regime, because I didn't want people to get off the hook for being accountable for the harms they create simply by pointing to the privacy policy that we agreed to, subject to this consent fatigue and this consent paradox. But if we can change the way consent is done, which is if we can make consent more just in time. One of the problems with this vast amount of information is that it also spans information that you may have given to this entity 10 years ago and you don't remember. So if you provide it just in time, it provides you sort of very contextual basis for providing that consent. And then secondly, if you make it granular, so you provide consent for the use of a small amount of personal data for a very specified purpose, then you can actually, all of us can appreciate that. And I think, we'll get into this, I guess, in more detail, but if you think about the DEPA framework, if I want a loan and if I'm, asking for 6 months bank statement, so this is actually something that I can easily grasp. I know what the consequences are. It's only 6 months bank data, and I know it's specifically for a loan. And if we can create a digital framework by which we can implement this, it's not subject to the consent paradox or consent fatigue, because these are things that are sort of easy to handle. Now, I think we need to address both these issues, the consent paradox as well as consent fatigue, in the implementation of DEPA. Because if we are not careful about how we implement it, we could, even in this I guess, more efficient way of processing consent come up with the same problems. And so, we really need to be mindful about that as we go down. And the reason I say it is because in 2011, 2012, when I was first thinking about the draft, consent was much simpler. When we provided consent, it was to a single website, and that website did a minimal number of things. And so providing consent was actually easy to understand. There was no consent paradox, there was no consent fatigue, there were much fewer websites. And now that's not the case. And so, look, I think we need to constantly learn from history. And even though I like the digital consent artifact that DEPA has created, I think at this point in time it's working fine. We've got to constantly be vigilant to ensure that we don't repeat the mistakes of the past and impose the same consent fatigue that we created DEPA to run away from.
Yeah. And much of the characteristics you outlined, which is around informed consent, purpose limitation, just in time in the context of the transaction, when I want to access your data versus collecting all of it upfront and then saying I will use it for whatever purpose whenever I deem so over eternity. Granular data access, so that again, as an individual, I really have the ability to choose what data I want, subject to also the use case and the use cases needs for the requirements of data, some of which may be compliance or regulatory driven as well. And so a lot of those characteristics, as you outlined, actually fit into the consent artifact of the data empowerment and protection architecture, because that's really a techno-legal approach where we can take the principles that have been outlined in this act and convert that into code, so to speak, policy as code, and embed that within the code, within the standards that then drive all activity on top of it. And so in that regard, how do you view this techno-legal paradigm? Because we have an act now. The act has certain principles. The act also, maybe you could touch upon the rights that it talks about with regards to individual personal data. But then how do we operationalize this act? There are tens of millions of companies in India, 1.4 billion individuals, and everyone can make a claim that my data is not being processed based on how I want it to be. And even though there are provisions for dispute resolution within the act and the creation of a new statutory authority, but how do we really look at it? Where we have this act, it wants to enshrine these principles and create more trust and minimize harm. But at the same time, we are 1.4 billion with so many companies. There's no way it's feasible if we just traditionally apply the mental models of taking legislation and just assuming it's going to be implemented. We'll only clog the courts further. So how do we look at legal approach to even think about solving for something like this?
Yeah, look, I keep saying that India is unique in that it's coming to this data protection regime in 2023, whereas Europe and the US have been thinking about these issues for 3 decades now. And so, they have built the institutional and organizational muscle to actually, comply with the obligations placed on data fiduciaries, as well as understand how to enforce the rights that are given to data principals. And India doesn't have that. And so India needs to really go from 0 to 100 very quickly. I think there's no escaping the fact that we need to change the way organizations operate when it comes to how they are currently collecting and using and processing data. It's so deeply wired inside sales teams of organizations that they can just sort of buy data sets and make sales cold calls, and it's okay. Or not only is it okay, it's, for many people, it's the only way in which they do sales. I mean, that's the only way they run sales for 20 years. So they don't know any different. But the data protection law is going to force them to change that mental mindset. So I think there's that whole process, the obligations on data fiduciaries and sales teams, and I think there's no shortcut to that. That's just going to happen through, even if we have to clog the courts, I think we're going to see some litigation around that, because that's very much a there's cholesterol in the system. It's going to take some time to sort of sweep the cholesterol out. But at the same time, if all you're doing is sweeping out the cholesterol without providing an alternative, it's not going to be effective. I think when companies realize that this old way of doing things is going to cost them, but there is a new way, we will push them towards, cleaning up the cholesterol themselves. And if you think about what the India's digital public infrastructure allows, it actually allows for this consented data sharing. So, I think the databases that you buy, you try and surface signal from the noise of that data to try and identify the customers who might be useful to you. But if you create a digital mechanism whereby you can do that much more efficiently, and you can allow market forces to do price discovery, which works for both sides. It works, the ideal customer for the kind of product you have, and the customer knows now that there's this basket of services that I have, and they can then provide their consent to figure out which one of those they choose, by increasing efficiency. So I think that we need both. We need sort of the carrot and the stick. If we just have the stick, which is the penalties if you violate your obligations, people will, after a while, it will become rent-seeking, right? They'll be like, look, I still need to get more customers, so I take the risk. How many people are they going to catch? But if you can give them an alternative, and you say that, look, there is a new way that you can acquire customers, and that new way is actually permitted under the law. It complies with all the principles of the law. You give them an incentive, in addition to the penalty, to change the ways in which they work. And I think for a country that's 30 years behind the rest of the world when it comes to this, you need something like that in order to really give effect to the law. So that's sort of the reason why I like the latest draft, which actually recognizes consent managers as sort of a class of its own. All the previous drafts sort of talk about them as data fiduciaries. This is the first time they actually don't even mention the word data fiduciary in the context of consent managers, sort of almost putting them at a different class. And of course, we'll have to see what how that plays out in terms of the rules and regulations and all of those that will be applied. But I like the way that framing gives us the opportunity to think more imaginatively about India's data protection jurisprudence. And I'm hoping that we'll have the opportunity to see that play out.
And one of the first places where consent managers are being implemented at scale is really within the financial ecosystem, right? Through the Account Aggregator framework, where we are seeing hundreds of financial institutions now come on board, participate in giving people control of their data via these account aggregators, and individuals or even businesses in this case having the ability to choose which account aggregator they want to use, and then go ahead and use that as an agent to then share data or with themselves or with other third-party entities in the ecosystem. And so as this has been rolling out, this has gone beyond, touching what you said, there's the lens of data protection, but also the lens of data empowerment, and both are key. And what we are seeing with the early implementation of the account aggregator ecosystem is it's also resulting in empowerment on the ground. So not only are you introducing consent, you're introducing auditable ways with which this can be tracked. You're giving people much more transparency around how their data is being processed. But it's also creating empowerment, because now I'm getting access to financial services that I couldn't get access to before, thus further democratizing credit or insurance or many other financial products that people were just either to physically access before, and therefore there's no competition, or even digitally, it's not so easy for them to access. And as we think of the future evolution of the account aggregator ecosystem, Rahul, what would be some of the key constructs that account aggregators should keep in mind, especially post the passage of the Act? And there are many key constructs in the technology of DEPA around consent templates and purpose limitation, and how do you make at least the principles of what should be informed, and informed can be something that's different to you and different to me. What do you make of that evolution that we'll see playing out over the years to come? And what are the ways we can address consent fatigue, for example, and address the complexity piece while still ensuring that individuals are in control of their data?
Yeah, so there's a lot to unpack there. So I think maybe the way to think about this is to take a look at the privacy principles. And we can't go into all of them, but let's just take a few, use that as an example, and we can work through the details. So most privacy laws, the DPDP Act is no exception, builds itself around a set of privacy principles that have been the same since the 1970s. Notice and consent is one of them. So a lot of them have many bases for processing, but in most jurisdictions, primary is notice and consent. And then there's what they call purpose specification, which is that you have to specify a purpose in relation to the personal data collected. You can't just collect personal data. You have to collect personal data against a specified purpose. It goes into a lot more detail in terms of, you can't just have an open-ended purpose. You have to get granular and detailed about the purpose. Then you have the data minimization. And if you think about it, these are these one builds on the other. So, after setting out purpose specification, you then need to go into data minimization, which is even though you've specified the purpose, and even though you're collecting data within the purpose, you must only collect as much data as is required to fulfill the purpose. So, if you could collect 1,000 data points, but you only needed 20 to fulfill the purpose, that doesn't give you the ground to collect 1,000 data points, because that would not meet the minimization requirement. And then there is data retention, which essentially says that you can only keep the data for as long as is required in order to serve that purpose, and no longer. So, even if you collect only 20 out of the 1,000 data points, you can't keep those 20 data points for like 10 years or 20 years if you serve the purpose within a year. So let's just take these sort of principles and then see how that plays out in the DEPA context. So first of all, notice and consent, the consent artifact, which is a digital embodiment of the concept of notice and consent, actually satisfies whatever you currently see in the papers that you sign and the privacy policies that you sign up to. It's all embodied within that construct. And in particular, notice, which around the world says that you must be provided notice which will give substance to your purpose specification, data minimization, and data retention principles. Essentially, your notice must have all those components. And so if you look at DEPA, it is possible to specify a purpose. It is possible to implement minimization, and it is possible to implement retention all through the electronic construct. But at this present point in time, if we think about DEPA as only the electronic consent artifact, and it is possible to use the electronic consent artifact to achieve notice and consent, but violate the purpose specification, minimization, and retention obligations that also exist, which is where consent templates and all the other elements will come in. So the way I see consent templates is consent templates, in a sense, implements digitally the purpose specification obligation, because the consent template and the data minimization obligation. So, the purpose specification says that you can only collect data for a specified purpose. And in many ways, as you write out the consent template, you will write out a consent template for a loan, you write out a consent template for financial management. That then becomes the purpose. But the template itself talks about how much information you can collect in order to fulfill this purpose. And that achieves the minimization obligation. Remember, when I say achieves, right now, once the law is passed, you have to achieve. There is no two ways around it. So even if you want to write up a consent template, which is basically turns the spigot on and you just can open all the water from this data silo, because of the minimization obligation, by law, you are prevented from doing it. And so I'm glad that DEPA has this concept of consent templates, which essentially takes the thinking out of it. If you subscribe to a consent template, and that consent template has just the amount of data that you need in order to fulfill the purpose, You just have to say, look, I'm going to invoke this consent template. This is the consent template that I need. It is, it is certified as being the minimal amount of information for achieving this purpose. That allows you to then comply with your statutory obligations under the DPDP Act without too much of an effort. And if you think about DEPA, ultimately DEPA is that. It takes a lot of these principles that are very generic principles when sort of it by definition they have to be abstract because principles have to be abstract, but then gives you a digital framework within which to make it real. I think it's up to us as we craft this ecosystem to make sure that we use the tools that the ecosystem gives us to then shape the ecosystem to comply with the DPDP Act. And I think that consent templates in many ways actually allow us to do that, but we have to take the trouble to craft the consent templates in order to reflect these various principles. And I think the whole ecosystem has got to come together. I mean, I would just say it's actually quite hard to implement in your workflow a minimization principle. So why do you want to do it yourself when you can actually just implement the principles in DEPA through a well thought through consent template, and then that then just becomes the way in which you function, and you know that is going to qualify with the minimization, public specification, retention obligations.
Absolutely. And in fact, I think what you articulated so clearly really brings to life the need for across ecosystems, different market players to come together to actually say, look, given the provisions of the Act, given the principles, and given our use cases and the context of the domain that we have, what are the right set of templates? What are the right principles based on the Act that we should now imbibe within our business workflows? And how do we actually imbibe those, enshrine those rather? And I think that will be very key. That's a new type of muscle I think many market players will also have to build. In regulated sectors, some of it already exists, but in especially unregulated sectors, or we are talking about healthcare, we talk about education, where you have multiple other regulators or multiple other stakeholders at play, this would be quite key. Otherwise, you could see some sort of misalignment taking place. So it's better for the market players to upfront start thinking together, saying, given these workflows, these templates are really what's right for customers at the end of the day. And it's interesting to just see this come full circle. I was reflecting as you outlined, from the launch of DEPA in 2017, where it was really about those technical tools, set of standards, basic tools, on top of which an institutional framework like consent managers, account aggregators in the case of financial data have been built out. And then the overarching legislative framework now fall in place with the DPDP Act, which will really allow this to flow across sectors beyond just finance. I mean, in the future, maybe I'm using my account aggregators to share other types of data, like I'm using it to share it for a visa processing use case. So I'm sharing my data with chartered accountants to help manage my accounts better, which today a lot of that data remains in silos, basically unleashing a lot of data that otherwise would remain in silos, but in a safe, protected manner. And I'd really like to thank you, Rahul, for sharing with us that legal overview of what DPDP really means, its impact it's going to have on companies across the board, how it actually impacts individuals at the end of the day in a positive manner, and what all of us need to do to actually now start to comply with different provisions of the Act, and also view it not just from a compliance standpoint, but I think it's also a great opportunity for other market players to build out new tools, data governance tools, new offerings to actually move the economy in the right direction. So thanks a lot, Rahul.
My pleasure. Thanks for doing this. I think it's really important to add this aspect, legal to your world and techno legal to my world as a lawyer, because I think we're seeing the confluence of these two.
Awesome. Thanks, Rahul. Okay, Ritvik, you can stop recording.